Hello and welcome to Global Property Transfer Systems, an Idiot's Guide. I'm using a casebook called Cases, Materials and Text on Property Law, which was edited by Erp and Bram Akkermans in 2012, and I've attached a picture of the book in case you guys want to look it up. It's a pretty hefty tome, but it's quite useful, and even though it was published quite a while ago, I've got to stress to you that none of this information is outdated. I'm only going to be discussing very basic principles and concepts to you, and this is going to be a very broad overview of property transfer systems in England, Germany, the Netherlands, and France. Hopefully, this will be very useful to students who are studying global law. As far as I'm aware, there's only 2 universities in the world that offer that subject, but maybe it should be useful to students of international law as well. So firstly, I'm going to discuss the 5 simple routes to owning something. These are occupatio, acquisitive prescription, commingling, specification, and transfer. And in the following slides, I'm going to give a brief definition of all 5. And it's important to remember that all 5 of these are relevant to the legal systems we're discussing. They're all recognized by all the legal systems we're discussing, and they're very important if you want to understand property transfer. So the first means of acquiring ownership I am going to discuss is occupatio, and actually this one only requires a really brief definition. It's pretty easy to understand. It simply means taking an object that isn't possessed by anyone and thus making it your property. So for instance, you see a rock on the ground, you pick it up, you put it in your pocket. It wasn't owned by anyone else before, but now it's yours. That is your rock now, you own it. You've acquired ownership through occupatio of the object. Second means by which you can own something is called acquisitive prescription, and that basically means holding on to something long enough that you become a rightful owner. So it doesn't matter if you're a little girl, if you've taken a locket from 103-year-old Margaret back in the 1920s, if you're 80 years old now and you still have that locket, it's probably fair to call it yours now. The third means of acquiring ownership that I'm going to discuss is called commingling, and this one is a bit, maybe a bit more difficult than the others to understand. The definition I put down is mixing 2 or more objects together to create a new object of which you become co-owner. Now, normally this isn't really a good thing for you. It means that your specific product has been mixed up with other people's products, and now because it's really difficult to specify which individual product is yours out of the many others it's been mixed up with, the courts can just say, well, okay, we'll just declare you all co-owners of all of it, rather than tracing what was yours and giving it back to you. In some cases, it's just impossible to do. The example I've given here is, for example, if different barrels of grain get mixed up together in the same shipment, you can't claim ownership of the original barrel of grain. There's no way of knowing which one was your original barrel of grain, so the fairest thing to do is to declare you co-owner, and that in itself is a new form of ownership. This 4th method of acquiring ownership is called specification, and it basically just means to make a new object. So you've made a new object, you've made something that no one else can make a claim of possession to. It's yours. You become the owner of it now. I put the example of someone making a car entirely out of sticks and stones, and that counts as making a new thing. What doesn't count as making a new thing is if you build a little part and you attach it to something that already exists. Then you're not the owner of that. It's become the component of something else that somebody else owns. The 5th method of acquiring ownership of something is called transfer. And I know I don't need to explain to you what transfer means, but actually there are so many different methods of transfer and it can get a bit complicated, but we will get to that in the next slides. So now we've discussed that transfer as a means of acquiring ownership is through transfer, but the kind of formalities a transfer has to meet to be recognized as valid and legitimate in a legal system, that's an entirely different matter, and that concerns whether the transfer system in question is monist or dualist, consensual or traditional, or abstract or causal. So we'll be discussing the definitions of each of these concepts in the next couple of slides. Now, a monist system only needs a declaration of intent for the transfer of a movable or immovable property to be valid, right? So the product doesn't need to be delivered to you yet for it to be under your ownership. But in a dualist system, you need both declaration of intent and the act of delivery to occur for the actual ownership to transfer. So as well as monist and dualist, there's also consensual and traditional systems that need to be distinguished from each other. And a consensual system is where only consensus over contract is sufficient to transfer ownership, and this is called the solo consensus law. In traditional systems, you only need delivery. That's the only mandatory thing for ownership to pass. Now, as well as monist, dualist, consensual, and traditional, there also needs to be a distinction made between abstract and causal systems. And the abstract system is really weird, and I think Germany is the only legal system that actually uses it. They call it abstraction principle, and it means that a contract doesn't need to be valid for the ownership to pass. So strange, but a causal system is where transfer of ownership depends on the validity of the contract, and that is more normal in my opinion. The next couple of slides are just going to be tables which will help you understand where each country fits into what transfer system, and I think it is a good idea to use tables when you're studying and revising because they help you to visualize and memorize information a lot easier than just reading everything in an essay format. England and Wales gets its own slide. That's because it's a little bit of a special one. It's a bit different from the civil law countries, and you'll notice that they use different transfer systems under equity than they do under common law. You'll also notice that it's not specifically causal or uniquely abstract. It uses both systems depending on the case, and there's a bunch of case law where they use different systems. In this section of the PowerPoint, we're going to talk about illegal contracts. See, I told you before that England is not specifically abstract or causal, it depends on the case. And here you've got a case, Singh versus Ali in 1959, where they're using the abstract system because even though it was an illegal contract, it did transfer ownership. The only caveat is that it's not technically enforceable because it's an illegal contract. In France, you've got a very different approach to illegal contracts. They're completely vindicated and the ownership never passed in the first place. They're just completely invalid. And in Germany uses the abstract system. So the transfer, like in England, stays valid, but the buyer may claim unjustified enrichment. And this could potentially lead to a restitution of property. So if you're transferring property through an illegal contract in Germany, you're not likely to get off completely scot-free with it. Now you've got to wonder, what is the protection for third parties in abstract and causal systems when it comes to illegal contracts? Because in France and the Netherlands, the nemo dat rule means the object never transferred in the first place, the ownership never transferred. Nemo dat means that you can't give away something that wasn't yours in the first place. But France and the Netherlands do have mechanisms to protect buyers who were in innocent good faith when they bought the property. In Germany, in case the contract has been avoided, The transferring party may have claim for unjustified enrichment, and the infringer may have to transfer the property back. Now, these are exceptions to the consensual systems, and if you go back a few slides, you'll see that a consensual system basically means that all there needs to be for a transfer of ownership to pass is a consensus over the contract. So England is a consensual system, except when it comes to issues of land under common law, and France is also a consensual system. And the exceptions to this are generic goods and also concerning future goods. And an important principle regarding this is specificity. So you can't, even if you have a consensus over a contract, it's the barrel of grains example again. If you got a consensus over a contract, well, I've ordered this barrel of grains, the ownership has transferred to me. If it gets mixed up with a bunch of other barrels, they can't trace back which barrel belonged to you in the first place. So this is an exception to the consensual system. You can't claim ownership of that specific barrel again. They have to create a new form of co-ownership. There are different methods of delivery of possession, which might merit some discussion. These are called traditio vera, traditio ficta, and traditio symbolica. And I've put the meanings of these terms down briefly in the slide. We can also discuss four methods of delivering movables specifically. The first being regular delivery, the second is something called brevi manu, there's longa manu, and constitutum possessorium. Again, I've put the definitions of all these terms down in the slide. We've discussed movables, but when it comes to transfer of land, there are other formalities that different legal systems may require. For example, in the Netherlands, Germany, and France, a deed is required. And in England, there are two systems of transferring ownership of land, and one is called the registered system, and the other is the unregistered land system. We're going to focus on registered land, and this also requires a deed, but that has to be done by a notary. There are also two other types of land registration systems that we could categorize all of the countries into. So the first is a positive land registration system, and this basically means that everything's in a lot more detail. You'll be able to trace the owner, all the rights are recorded, there's a careful check on the deed, it guarantees accuracy. But there's also a negative system of land registration, which is exactly how it sounds. It's you're registered, but there's hardly any details there, and it's difficult to trace the owner in this system. Issues may arise when other parties are also interested in the land that you're interested in, and there's something called a constitutive effect of registration in England and Germany. So in Germany, you're protected by public faith of the land register in German law. And even if you haven't bought something yet, you've got something called a Vormerkung, which is a priority notice. So Germany protects you pretty well from other parties interested in the land. So does England, so does Netherlands, and in France, the first person to be registered gets the land. Now we're going to briefly discuss the ownership of something called a claim. So a claim is the right to the performance of another, and a right of ownership can be extended to claims in France and England only, but it cannot be extended in Germany or the Netherlands. You can transfer ownership of claims either through original acquisition or derivative acquisition. So original acquisition is where you receive a right that didn't previously exist, and derivative acquisition is where someone's giving an existing right to you, and we call that assigning a claim. And we're not using consensual tradition, monisties, whatever that dichotomy was for the other property rights, because claims don't meet the requirements to count as a property right. So there's a separate system of transfer that exists for claims. Here you'll see that to transfer ownership of claims, different legal systems have different requirements. So Germany, to sign a claim, you need a contract. In France, you need a contract and a formal notification to the debtor. And in Dutch law, you just need delivery of the deed. And in English law, you need statutory assignment or equitable assignment. There's also an issue over who gets priority if the creditor has assigned the same claim to multiple people. So in most legal systems, you need to give notice to the debtor. So that's what matters. It doesn't matter at what point the creditor assigned the claim. It just matters when you gave notice to the debtor. So whoever does that first. A pactum de non cedendo is basically a non-assignability clause. So it's a clause that you can sign to reserve your claim and not have it assigned to anyone else. And in English law, it's very enforceable. But in France, the Netherlands, and Germany, it is enforceable, but it's got loads of exceptions, like merchants, for instance. So it's not that useful. We're going to discuss the right of usufruct in respect to claims. Usufruct means the right to use and enjoy fruits of something. So, for example, if you've been granted the right of usufruct in respect to a plot of land, if there's a tree growing on that land, you've got the right to enjoy the fruits that grow on that tree because it is on this land and you're the usufructuary. Common law does not recognise usufruct, so when we talk about it, we're only talking about civil law jurisdictions. So this is the end of my brief overview on global property transfer systems. I hope it was very useful to you, and if you've got any issues or anything that you don't understand or any topics you want me to talk about in future, just drop me a message or write me in the comment section below. And I also hope that these case law questions might be a bit useful, might help get your brain into gear. And remember to keep doing case law questions, because law isn't just about memorizing this information. You've got to be able to apply it too. So thank you, and speak to you again next time.